Hello, everyone, and welcome to our webinar on the SEC's Supplemental Proxy Voting Guidance for Investment Advisors. As Megan said, I'm Sara Buescher with the IAA, and I am delighted to have here with me virtually today, Sara Covitz and Steve Stone. I'm now going to turn to them for introductions, starting with Sara.
Thank you, Sara. Thanks for inviting me to join you today, and welcome to everyone. I'm Sara Covitz. I'm a partner at Stradley Ronon, providing advice to advisors as well as with regard to investment companies. Before I joined Stradley, I was at the Securities and Exchange Commission for a really long time and spent most of that time in investment management, mostly in Chief Counsel's office, where I was involved in prior SEC guidance around proxy voting. And so this is an issue that I'm actually quite passionate about and very interested in. So I really appreciate the opportunity to talk to you all about it.
Thanks, Sara. Steve?
Thanks, Sara. And actually, I should say the Saras. And greetings, everybody. Happy Friday. So like Sara C., this is a pet issue of mine ever since the 1990s. And it's been fascinating to watch the changes in the law and guidance and perspective on these issues. And we're at a unique time where there are a lot of points of guidance from regulators, but they don't necessarily connect up. So this is indeed a session to start going through some of the puzzles that are left by the 2020 guidance and some of the related initiatives. So thanks for having me.
Thanks, Steve. And as I said, I'm Associate General Counsel with the IAA, and I cover proxy voting and other investment advisor issues, and also cover ERISA and retirement for the IAA. So for our agenda today, we're going to cover a number of topics. First, we're going to start with some background, both under the Investment Advisors Act and other areas that you need to consider when thinking about proxy voting. We're then going to talk about the rule amendments for proxy advisory firms. And then we're going to get into our primary topic, the supplemental guidance for investment advisors. We're also going to talk about the 2019 guidance for investment advisors on proxy voting and some observations from that. And then we're going to leave you with some takeaways. And one thing that I would encourage you to do is please feel free to ask questions during our presentation today. We have set aside some time for questions, and we would love for you to send those in. It makes it interesting for all of us. So with that, let's move on to some background. And first, we're going to start with background under the Advisors Act. And we're going to cover two areas, the Advisors Act fiduciary duty and also the advisor proxy rule. Sara, let's get started with the Advisors Act fiduciary duty.
Sure. So the basic fiduciary duty everyone is familiar with, you know, in making a voting determination, an advisor has to act in the best interest of the clients generally, right? And I think that what's interesting about the proxy voting as a fiduciary duty, it's always been in a sense a bit political in nature, right? So the SEC sort of made proxy voting an explicit duty of care way back in 2003 after, you know, an issue with a corporate merger where the SEC brought an enforcement action against an asset manager alleging that it had switched its vote at the last minute based on some threats from the issuer to lock its parent company out of future deals, right? So, you know, this sort of background to the fiduciary duty with regard to proxy voting kind of set the tone for it, and it's continued that way sort of along the path. So the fiduciary duty has, over the years, there's been a lot of sort of lore and guidance around it. And I think you see in the 2014 guidance the staff put out, and again, the 2019 staff guidance, you see this sort of tweaking of what was originally a very clear, explicit, you have a fiduciary duty to vote kind of feeling in the original rulemaking, right? So now you have guidance and lore about the duty certainly depends on the scope of authority assumed by the advisor. If you have not agreed to take on proxy voting, you don't have to do proxy voting, right? You have to have an understanding of what the client's objectives are. You can't make your determinations with regard to how to vote if you don't sort of understand where the client, what they're looking for. Again, determinations in the best interest of the client, and then determinations not based on materially inaccurate or incomplete information, which gets to a topic we'll discuss a lot, sort of, you know, how do you make your determination and what kind of information are you receiving, and are you receiving information from third parties with regard to how you're going to vote?
Yeah, thanks, Sarah. That last point, we'll talk about this more too, is also use of proxy advisory firms. And so the SEC has made statements around that. So in addition to fiduciary duty, Steve, we also need to consider the Advisors Act proxy rule.
Sure do. And as Sarah mentioned, that's a rule that was adopted in 2003. It came to pass based upon some enforcement matters that focused on conflicts of interest. And there also have been examinations that also focus on other types of conflicts of interest, such as advisors voting proxies not based on necessarily how they viewed client best interest, but to curry favor with certain segments of clients who wanted them to adhere to a certain set of standards. So while the rule 2064-6 was prompted in large measure by conflicts of interest or issues that implicated the duty of loyalty, it is also about the duty of care. And of course, it makes it a fraudulent practice to exercise proxy voting authority unless an investment advisor has policies and procedures designed to ensure that proxies are voted in the client's best interest. It also provides for disclosure of how clients can find information about how proxies are voted, and provides for some disclosure of the practices and policies that an advisor has. It also establishes an interesting presumption. And this follows on the 1994 DOL pronouncement, and essentially says that if you have investment discretion, without regard to whether the agreement says one way or another you vote proxies, you have the responsibility impliedly to vote proxies. And if you don't want that result, your agreement with the client has to say, you're not going to vote proxies. And indeed, the Department of Labor spoke in terms of a firm being actually precluded from voting proxies because that authority is reserved to another fiduciary. And so this other notable aspect is the policy and procedure facet of this rule was a foreshadowing of what would later come at the end of that year, which is Rule 2064-7. And both come into play when it comes to the SEC's evaluation of how firms approach proxy voting.
Thanks, Steve. So in addition to the Advisors Act, there are some other things you need to consider when thinking about proxy voting. Sarah, why don't we start with the Investment Company Act?
Sure. So at the same time the commission adopted the rule with regard to proxy voting for advisors, there was a similar rule for funds, for investment companies, where again, you have to have a policy and procedure with regard to your votes. But interestingly, with regard to the investment companies, there's also a disclosure requirement of how you vote, which has really led to a very intense focus by media, by academics on investment company voting, because that's what's available. That's the kind of information that's out there. And so I think that also has sort of played into how proxy voting has gone over the years, because there is a ton of information about how funds vote, right? So the ICI estimated in 2017 funds cast 7.6 million proxy votes, and information about how they voted is pretty much available for almost all those votes, right? So it's a rich lore of information and data that then sort of is used and spun and creates a focus on investment companies and asset managers who run them with regard to proxy voting.
Thanks, Sarah. So another thing to consider is ERISA. And this is an area where I think traditionally ERISA fiduciaries, the view is that you need to vote proxies as an ERISA fiduciary. But interestingly, the Department of Labor recently came out with a rule proposal around proxy voting. And I would say it's a game changer, because as proposed, what the rule says is that the plan fiduciary would actually be prohibited from voting a proxy unless it prudently determined that that specific matter had an economic impact on the plan. And conversely, it would be required to vote if it did determine that the matter had an economic impact on the plan. And so this is something we are going to have a member call next Monday to talk about this proposal and consider potential comments. So stay tuned. This is an area, as Steve mentioned in the beginning, there's multiple regulators in this space. So it'll be interesting to see what happens there. Steve, what about international issues? What are the issues there that need to be considered?
Sarah, on the international front, I think the biggest blip is the Shareholder Rights Directive out of the EU, or otherwise known as SRD2. It was enacted a couple years back, but it's being transposed, or the requirement that it be transposed into law by the member states is due this month. And the focus is on identification of shareholders and facilitation of proxy voting. So it's mostly focused on making sure that issuers have information concerning shareholders so they can communicate with shareholders. But there are also pieces that affect investment advisors, including providing for disclosure of essentially their approach to engagement on shareholder rights issues.
Interesting, thank you. One thing I forgot to mention on ERISA, that DOL proxy proposal comments are due on that soon, Monday, October 5th. It's another quick turnaround, so meant to mention that. All right, so at the same time that the SEC issued supplemental guidance for investment advisors on proxy voting, it adopted rule amendments for proxy advisory firms. And both of these were done by a 3-to-1 vote with Commissioner Lee dissenting. So Steve, let's talk about those rule amendments for proxy advisory firms.
Thanks, Sarah. Maybe stepping back for a second, and I guess we probably should maybe advance to slide 1. The proxy changes were a set of comprehensive and controversial amendments to the rules governing proxy solicitations. Importantly, the changes codify the SEC's interpretation in the past that proxy voting advice itself constitutes solicitation of proxies for purposes of the proxy rules, which brings into play potentially both the reporting disclosure requirements under the proxy rules. And as such, it also brings into the spotlight proxy voting and advice and related disclosures and the interaction between proxy voting advisors and issuers in terms of them articulating issues they have, concerns they have on a given proxy matter, and the interchange with proxy voting advisors and issuers. So it creates a narrow exemption from the information and filing requirements under the proxy rules for proxy voting advisors with 2 important conditions. Issuers must have access to proxy voting advice before, at the same time, it's provided to the advisor's clients, including, of course, RIAs. And number 2, the proxy advising firms must provide clients in a timely manner with a mechanism to make them aware of additional information provided by issuers, so that if they're getting advice from the PAF, that they can also factor in supplemental information or responsive information provided by the issuer. There's a lot more to it, but that's at least a thumbnail sketch.
Thanks, Steve. One thing that I would say here, that the IAA was pleased that the SEC did not adopt the proposed advanced issuer review and notice processes. We and others advocated for those to be removed. Another area that we commented on was regarding custom policies that are developed by investment advisors. And we argued that when a proxy advisory firm provides advice based on custom policies, that should not be provided to issuers because it may reflect confidential or proprietary information. Sarah, tell us about what the release says about custom policies.
Sure. So this is one of those areas where it always pays to read the footnotes in an SEC release. So there are a couple of footnotes that talk about custom policy and what the SEC actually means by custom policy, and I think it's a fair warning. So I think people should pay attention to those footnotes. So basically, what the SEC says is we hear the IAA, and they had a good point about custom policies. We don't mean to include custom policies, but when we say custom policies, we really mean custom policies. So if what you're doing as an investment advisor is taking a proxy advisory firm's benchmark policy, one of its standard policies that it already has and it exists, and kind of adding a few bells and whistles to that, when we say custom policy, we're going to mean only that part that's truly custom. And so any vote that would have to do with what is truly part of that benchmark would still be subject to, and the whole point of this is that it would still be subject to the notice provisions for the issuer, that the issuer has a chance to object to the report, and that the issuer then, the proxy advisory firm then has to provide notice to clients, asset managers, investment advisors that the issuer did object or what the issuer's objection is with the hyperlink, right? So it is important to realize that if you're going to try and use a custom policy, it really needs to be a custom policy. If you're going to try and rely on this as a means of not having that information come to you with regard to the issuer's objection, it really needs to be a true custom policy. Otherwise, the information is going to still come to you from the issuer. It's going to be the benchmark policy.
Right. So if it is a true custom policy, then that would not be shared with issuers. But if you just take a proxy advisory firm's policy and try to make it your own custom policy, that's where the questions may come up. So, okay, thank you. We should also note in this area, there is still some ongoing litigation on the status of proxy advice as a solicitation. So we'll see what happens there. Also, just to close out the SEC's actions around proxy voting, they have scheduled an open meeting for next Wednesday, September 16th at 10 a.m. Eastern regarding adopting amendments on shareholder proposals. So with that, let's turn to our main topic, which is the supplemental guidance for investment advisors. First, let's talk about why the SEC provided this guidance. Sarah, I'm going to turn to you for that.
Sure. So, I mean, I think the SEC basically, it's tied, this guidance that just came out is tied very closely, obviously, to the rule release. And so the idea being that there is this anticipation now that there will be this process, this mechanism by which issuers can, you know, comment on reports, and that information needs to go to the clients, to the investment advisors. And I think that it's interesting because, you know, the major proxy advisory firms already had a version of this mechanism available. And so it may not be, you know, a huge surprise to investment advisors that, you know, there is information that comes. There may have been, you know, issuer reports that would have been made available to advisors in the past, but now there's a very distinct mechanism for it that will, you know, require the proxy advisory firm to provide that information to advisors. It's quite clear that this, you know, is a mechanism to make sure that issuers can get information that they think is important if they think there's an objection to or a problem with the proxy advisory firm's advice. And so I think, you know, as Sarah said before, it's great that they did not finalize the original proposal, which would have had the issuer actually receive the information and the report and be able to comment on it before it even got to the client. Now it's going at the same time. But, you know, it has really transferred to advisors, as we'll talk about, you know, in much more detail with regard to the guidance, sort of the need to address how any additional information comes out. And so while it's no longer on the proxy advisory firms to provide, to give that opportunity to the issuers before they put out their own advice, now in a sense it's been transferred to the client, the investment advisor, to do something with the information that it receives.
And as far as, you know, they also talked about, with Sarah, as you were talking about the issuer information, they talk about disclosure obligations and policies and procedures. But one thing I do want to clarify here, people may be under the view that if they don't use proxy advisory firms for recommendations on proxy votes, if they just use them for the voting platform or for voting execution, then they don't need to worry about this advice. But that's not the case, right?
Right. So I think the guidance is very, very clear here that, you know, the majority of the commission who passed this guidance wanted some form of speed bump. The speed bump wasn't actually passed through the rulemaking, but through this guidance, there has been now a bit of a speed bump with regard to automatic voting. So if an advisor, you know, finds out, gets information from an issuer that there's a comment, the advisor needs to consider whether that would materially impact how they plan to vote. They shouldn't just be automatically voting and ignoring that information.
Yeah, and I should say, we at the IAA were pleased that the SEC did not adopt a speed bump or click through. We argued against those, but in some sense, the guidance, you know, that may have been what was put in place instead of that. So, all right, so let's get into the guidance itself. Steve, like the last year's guidance, it kind of took a question and answer format, although this time it seemed to be one big question. So why don't you walk us through that?
Yeah, it was interesting, and I think some of us were puzzled as to why they felt the need to put this out, given what was said in the 19 guidance. But essentially, they did focus on how an advisor should approach a situation where an issuer is going to be providing supplemental information. And there they said, an advisor should consider whether its policies and procedures address circumstances where the advisor has become aware that an issuer intends to file or has filed additional soliciting material with the commission after the advisor has received the proxy advisor firm's voting recommendations, but before the submission deadline. In such case, if an issuer files such additional information sufficiently in advance, and I underscore that, of the submission deadline, and such information would reasonably be expected to affect the advisor's voting decision, the investment advisor would likely need to consider such information prior to exercising proxy voting authority in order to demonstrate that it is voting in the client's best interest. So a couple things that are interesting. I think it's probably fairly intuitive that if facts change in a decision that an advisor makes, that the advisor should consider those changed facts. It's also interesting that the SEC is focusing not so much on the duty of care as a conceptual point, but really on the advisor's policies and procedures, which I guess is one way to approach the issue. I think the SEC has long viewed the 20647 as well as the proxy rule as being a way to bring actions against a firm for having defective procedures, even if the commission cannot prove that there's been a substantive violation. But at least that was interesting to me in terms of their focus on policies or procedures.
Yeah, and it seems like here firms are going to need to take a step back and decide, based on this, what are they doing now with respect to information from issuers? And do they need to make any changes? But again, you can't just make a change to policies and procedures in a vacuum. You need to think about what have you disclosed to clients? What are your agreements with clients? One question we got ahead of this webinar was, the way that this guidance is written, it says that the information would reasonably be expected to affect the advisor's vote. And somebody made the point, well, what if I don't own much in this issuer? Why should I spend an inordinate amount of time looking at what an issuer has said when I don't own much of it? And personally, I think that's a reasonable, it's a reasonable concept. I think you just need to be aware of the fact that this, yeah, exactly. But you have to be aware of the fact that the standard here is, would it be expected to affect the advisor's vote? So something to keep in mind. So we got a good question. What are some examples of when or how an advisor would become aware of additional information from an issuer? And Sara, you mentioned this earlier. It's our understanding that that certainly from the proxy advisory firm standpoint, they have processes that they use to send their clients, if they send investment advisors information saying, Acme Widget Company has an additional statement in response to our recommendations, here it is.
So the proxy advisory firm, these issues have been around for years, and the corporate issuers for many years have been complaining, and I'm sure some of it is somewhat legitimate. I'm not sure all of it is totally legitimate, but complaining that the proxy advisory firms, made factual errors with regard to the underlying data that they use to assess a vote. And so that might have influenced the way that they recommended. And so the idea for many years has been, geez, issuers should have a chance to comment or to show the proxy advisory firm, we all know the proxy season is quite short, times get compressed. It's hard to reach people back and forth, right? So the issuers, we're saying, look, we need some kind of system, some kind of way if there's a problem with the report. And so the proxy advisory firms did respond in some sense to that already, even before this rulemaking. So as I understand it, for ISS, if you were sort of the biggest issuers, you would have a chance to see the full report along with the recommendation. That was just the really big issuers. For Glass Lewis, in the last couple of years, they've started a service for any issuer. If you sign up for it, it was free. You could see the factual underpinning, the data that they were going to use to make the report. And so already for the past few years, there has been an opportunity for issuers to have some say, or to make a further statement, put out some further public information about what they might see as a problem. And so that would be how I think the advisor would see it, right? You would already have this information available from the issuer even before this rule, where there might have been, they thought there was a problem, and that might have gotten blasted out.
Yep. And we just got another really good question, and this kind of hits it as, does the review of material come into play? Does the review of issuer material come into play if you hire a proxy firm to automatically vote? And that's exactly, I would say that's exactly what this guidance is getting to. That's what the SEC is talking about. Even if you're using a proxy advisory firm and you've done your due diligence to hire them to take care of proxy voting, what the SEC is saying is, and not that anybody does this on the webinar here, you can't set it and forget it. So if you do get information from the proxy advisory firm, they notify you about information from an issuer, then you need to take, they're saying they want you to take a look at that if it's going to be expected to change your vote.
And even more broadly, if you find out that information, even not through the proxy advisory firm, but if that information comes to your attention in any way, right, you have a duty with regard to your voting to not just automatically vote in the way that you had pre-populated on the proxy advisory firm's systems, right? So you may have had your own version. You didn't rely on any of their reporting. You made your determination on how you wanted to vote, but you have them doing pre-populated votes based on what you had told them. If information comes out between the time you told them and the time that reasonable, we could talk about that, but reasonable information, reasonable amount of time, what the SEC is saying is you can't ignore that later information if it might have an impact on the way the way you had planned to vote.
Yeah. We also got a good question about, does the SEC expect you to get this information directly from the issue and the proxy advisory firm? That I don't think is an issue. I don't think the SEC cares how you get the information. You know, if you don't use a proxy advisory firm, then the issuer is just going to send it to you directly because you're doing the voting. But yeah, but it doesn't depend. I don't think it matters which way you would receive it, I would say. So, all right. So lots of good questions here. So let's move on, Sarah. Another point that's made in the guidance, it talks about agreements with proxy advisory firms. Tell us about that.
So the other interesting piece here was this concern around the proxy advisory firm maybe having non-public information about how an advisor intended to vote that it was going to share with others. And I think we were having our pre-call and Steve made a really good point. I think what they're really concerned about here is there a proxy advisory firm that's going out there as a sort of a marketing tool for its own business and saying, look, not only can we do voting for you, we can let you know how the big guys are voting. Now, I don't think that's happening. Maybe there's information out there that I'm not aware of, but I think that's where this particular piece of the guidance comes from. And so I think the idea would be, you know, as you're doing your contracts with your proxy advisory firm, that there would be some confidentiality provision in there. I imagine that there already is a confidentiality provision in there in those agreements. And so I don't know that that's a big change, but I think that that's just something that you should keep an eye on in your agreements with the proxy advisory firm should you choose to use one.
Steve, would you agree with that? Do you typically think that these agreements probably already have the confidentiality provisions in them?
I can't give you a broad sense of market practice. They certainly should.
Yeah.
And so that you don't want the consulting arms of the proxy advisors to use, exploit, or disclose your confidential information about how you may vote.
Yep.
Obviously more important with large managers because of the influence that they have. But it goes to the heart of what has been a concern about the dual business of the proxy voting advisors of being a fiduciary to advisors and their clients on the one hand, and also being a consultant to the issuers.
So again, you know, I think this is one where your agreements likely already include a confidentiality provision, but definitely, you know, take a look at that. We also got a comment back that one firm did ask a proxy advisory firm to provide them with information about confidentiality in their code of ethics. So,
yeah. Well, and this goes back to the guidance that was issued last year, which is what kind of due diligence an advisor does of a proxy voting advisory firm.
Right. So. Okay.
Yeah,
Steve,
Sarah, real quick, there was another question, which I think it's an important point to make. How often does additional information come out from an issuer? And not to answer that specific question, but to make a broader point, you know, I talked earlier about the thousands and thousands and thousands of proxy votes, but keep in mind that, you know, 90 5% of those votes are really not controversial at all. So what really is the concern here is those votes that really do matter, whether it's a shareholder proposal or boards or whatever it is that might be more controversial. That's really where this focus is. Now, you can't obviously ignore the other votes. Your policies and procedures have to address everything, but that's really where the SEC's concern is. And that's why this has been such a big issue, is that there has been a sense from the issuer community that on some of these very, very important votes, somehow if the proxy advisory firm got the recommendation wrong, and one can talk about whether it was wrong or not, what the issuer would have liked, how has that impacted voting? And so that's really what you have to keep in mind is sort of the policy framework behind this.
Yeah, that's a good point. Most votes are uncontested, so you're not going to get any issuer feedback. But for those that are, and this is kind of drilling in on a narrow area, so I think it's very helpful to make that point. The other point, Steve, that we want to talk about, because this was, in addition to policies and procedures, disclosures was the other area discussed in the guidance. So let's talk about that.
Let's talk about that. It's interesting, in taking a look at this relatively short guidance, it frames the issue in terms of an obligation of an advisor, of course, as a fiduciary, to provide full and fair disclosure of all material facts about the advisor's relationship with clients. And they go on to follow the 2019 Advisors Act interpretive relief to say that disclosure has to provide sufficiently specific facts or information so that a client can make an informed judgment. And then based on that, says an advisor should, quote, consider whether they should disclose the use or the extent of use of automated voting and under what circumstances an advisor uses it, and how the policies and procedures address circumstances where they become aware of additional information so that they're not, as you said earlier, robo-voting. So it's interesting to me that the SEC has jumped to a conclusion that this is important information, because it seems to be the level of granularity that typically isn't covered in how we approach other investment judgments under the duty of care. But that said, if you're following the SEC's guidance, you should consider these facets. At this point, I don't think if you look around the street, you'll find pervasive disclosure of these issues. And it'll be interesting how the market evolves in terms of what level of disclosure or specificity of disclosure is out there.
Yeah, and then this is the other point about disclosure, making sure that, like you mentioned, the level of detail, is it enough to allow the client to provide informed consent? But I would agree with you, Steve. I think so far, I did just some review of some form ADVs, and many discuss the use of a proxy advisory firm and the services that they use them for, not only for advice, but also for execution. Some also talk about that they do review information from issuers, but certainly this use of automated voting platforms, it's more detailed. So people are going to need to take a look at their disclosures.
And I know, Steve, you're going to cover this a little bit later, the earlier guidance, but it does, in a bit of a sense, follow on from the 2019 concern, the guidance concern that votes weren't actually being counted the way they were supposed to. And so there was the guidance piece about, should you be sampling how votes actually end up being cast to make sure they were cast correctly. And so this, in a sense, sort of follows on, again, a level of detail you wouldn't expect necessarily to see, but it's another piece of the same kind of concern.
Absolutely, Sarah.
Yeah, and I think a key point here to keep in mind on disclosures is, to the extent right now, I think it's what's not going to be sufficient going forward is just saying, we use proxy advisory firm and they take care of all proxy voting. And that's all that's said. I would say going forward, that's not going to be enough. I think you'd have to discuss, what services do you use them for? Also need to think about that guidance related to review of issuer information. And that ties into this use of automated voting platforms. And if you use that, does it allow you then to review additional information that comes in? And Steve and Sarah, I'd be curious about your thoughts too, about people's adjustments to disclosure.
Yeah, I mean, I think there are two pieces, right? So there's your policies and procedures, and do you need to make tweaks to that? And then there's your ADV disclosure and what's there. I mean, in a sense, both are disclosed because your policies and procedures have to be available if someone asks to see them. If it's a fund policy, it's going to be out there anyway because it's part of the fund process to have the policies and procedures, and usually that's the advisor's policy. And so you have the policies and procedures where I think, you know, you might expect to see a little more detail about what you're actually doing and how you're thinking about it. And then you have the ADV disclosure where, as both Sarah and Steve have pointed out, like it's just not common to have this level of granularity with regard to a service like this. So I agree with Steve. It's going to be very interesting to see, you know, how you can, are there ways to address this that fit within the norms of what we normally see in an ADV.
And just to, not to go off track too far, but it's interesting that the SEC has framed the obligation for disclosure as providing material information about the relationship in sufficient detail so the client can provide their informed consent. Usually you think of that in terms of conflicts, where you have to provide enough information the client can make a sensible and informed judgment. Duty of care, particularly across a realm of different investment judgments, you don't really get into the minutiae of how you reach in a given investment judgment or how you react to additional information. And so when I see consider, I think I would take it on face value, which is consider it. And that does also mean that you may conclude that it's not required in particular circumstances. Whether the staff will have an expectation that they'll find it, we'll see.
Yeah, no, it'll be interesting to see at what level, because I would agree. I do think this goes beyond what you would typically see, you know, Form ADV. But again, I think the point here is you're going to need to go beyond just saying you use the proxy advisory firm and they take care of everything. I think that's a bottom line point. And then Sarah, you mentioned this, you know, they talk about policies and procedures, but also related to disclosures, right?
Right.
So, and again, here I would look at what are your policies and procedures around your Form ADV right now, and do you need to update them based on this new proxy disclosure? So I think before we move on, we'll take a few questions based on the supplemental guidance. One question came up on the definition of of automated voting. And, you know, the definition, they talk about the use of automated voting, particularly as it applies to automated voting platforms that are provided by proxy advisory firms. That's how I would see that. Sarah or Steve, do you disagree?
No, I think that's right. I think the focus is on the proxy advisory firms, but again, you know, you may have some kind of internal platform within your own investment, if you're, you know, within your own shop. So if you're personnel that's actually making the determination and you're, you know, IT professionals or other professionals who are actually doing the actual mechanics, right, you'll have to have a conversation between them, even if it's not a proxy advisory firm.
And Sarah, you mentioned earlier about timing, and we did get a question about this, talking about updating our proxy voting policy, that our firm will review additional information from issuers as long as it's received at least 3 days leading up to the meeting date for domestic securities and 5 to 7 days before the meeting date for international securities, in order to give us time to review and act on that information. And they were thinking, how does that sound? I mean, we can't certainly opine specifically. It sounds reasonable to me, but I'd be curious to hear if either of you are starting to get these kinds of questions and what you think of that.
Yeah, no, I mean, I think people are going to have to make these determinations around reasonableness and reasonable amounts of time, right? It's built into the guidance itself, the rulemaking itself, sort of a timing because of the way that the exemption requires the issuer to have provided, you know, feedback in a certain amount of time or provided their information. So I think the timing point is one that the SEC has to understand. You can't be expecting people to change their vote if the information comes out at the very last minute. Where that falls in their mind, you know, we'll have to see, and how people can sort of make their own determinations. They're going to have to kind of think about what's reasonable, how material is it, all the considerations we've talked about.
But that kind of process is an excellent thing to start thinking about, just how that was phrased. We also received a question about, let's say there's a situation where an issuer provides a dissenting opinion at the last minute, and I, as the advisor, disagree with that opinion and do not change my vote. How do I prove that I considered the issuer view, and how detailed do those policies and procedures need to be? They also raised the concern about issuers slowing down the voting process, which I think is a whole other topic. But as far as, I think here the importance is documentation, making sure that if you receive information and you consider it, but decide to, not vote in line with that, do you document it, right? I mean, I think that's what's reasonable here. And again,
although one thing I just point out is that I don't recall that the SEC said that there was an obligation to document that determination. They may say that your policies and procedures are not adequate if there isn't documentation.
Right.
But documentation always sounds good to we lawyers, or to regulators, but it's sometimes something that gets slipped up in practice.
Yep. Yeah, that's an excellent point. And I think you're going to need to consider for your firm what's reasonable.
Right.
And don't put it in your policy and procedure if you can't do it.
Exactly.
Excellent
and think from the standpoint of typical investment judgments. I like this stock, this fact has changed. You document your deliberation? Probably not. Your investment professionals don't do that because they're doing lots of different things. So come up with an approach that makes sense, though.
Right. That makes. Okay. So trying to advance the slide here. Oops. Okay, so the next issue is around timing. And this is a little tricky because what the SEC said is that proxy advisory firms have to comply with certain provisions of that rulemaking by December 1st of 2021. But the investment advisor guidance, like guidance typically is, becomes effective upon publication in the Federal Register, which occurred on September 3rd. So the questions are coming up, and I think we actually got a question through the chat about, well, when am I expected to update my policies and procedures? And when am I expected to update my disclosures? And unfortunately, the SEC is unlikely, because this is guidance, they're unlikely to come out with anything and say, you can wait until next year, next March to update your disclosures. They're not going to come out with anything specifically on that. But, when thinking about the timing of this, certainly if you're going to make changes to things, it's a good time to start looking at, do I want to make any changes in my process? And then, as far as changes in discussion, what kind are you thinking of? And how significant are they? And Steve, I'd like to turn to you and then Sarah to talk about this issue.
Sarah, I agree with you. And frankly, I was thinking that given all that's going around, because the last year has changed, and I'm not sure all firms have really absorbed the guidance that came down this year, the way the market will be responding in the meantime in terms of the PAFs coming into effect with, or into compliance with the framework by next year, plus the DOL rule. There's a lot to consider. And I think that in this circumstance, I don't think it's the case necessarily that firms have to, on the dime, change their policies and procedures or change their disclosures, but they should take a look at their overarching approach and essentially approach this holistically. What are our obligations as a fiduciary when it comes to proxy voting? What are the perspectives that we learn from the Department of Labor or the SEC statements in that regard? What do our IMAs say? What do our disclosures say? And how should we be approaching client best interest from the standpoint of proxy voting, consistent with what we were talking about, separating the routine from the important matters, and those matters where we have a significant position such that our clients really have a vested interest in us voting the proxies.
Thanks, Steve.
So I think I would approach it holistically at this point.
Sarah, what are your thoughts on this?
So, I mean, I think I totally agree with Steve. The other point I would make is that, there has been a succession of different pieces of guidance over the years. And I think the speed with which you need to address the most recent guidance also needs to factor in how much you've done with regard to the past pieces of guidance. So, you know, there was 2014 SLB, there was the 2019 guidance, now there's this 2020 guidance. If you haven't done anything and your policy and procedure still says, you know, 2010 on it, it might behoove you to more quickly address and start to make some updates based on all of the pieces of guidance. But if you've been sort of making changes along the way, again, with all that's going on, I completely agree with Steve, not to mention the fact that, you know, ISS is actually suing on the rulemaking. I think their lawsuit has been back up. So it's very, it's complex, how these pieces are all going to fit together and how they're going to all come into play and whether they all come into play. But I think you do need to think about sort of what you've been doing along the way and how much, you know, you've made changes prior to this most recent guidance.
I think that's a good point. And most of the questions I've received so far have been around the disclosure. And again, that gets back to, you know, is it material? Meaning, would an average client consider it to be, you know, to be material or significant? So, so again, it would have been nice if they had said everything by December 2021, but this is guidance, so different rules apply. All right, so now let's take a look back at the 2019 guidance. This is, we thought it would be helpful at this point to talk about what came out last year and what are some observations. Let's start with the difference, Sarah, between 2019 and 2020.
Sure. I mean, I think the 2019 guidance was more general. It followed along, I think, relatively closely to what the 2014 staff legal bulletin had said and added a little bit of bells and whistles. It wasn't that there was no differences, but sort of had that same feel of a very general, broad fiduciary duty. How do you think about all of these issues? I mean, the 2020 guidance, as we've already pointed out, it's a very narrow and specific focus, you know, tied to the rulemaking, but again, the timing of it is not tied to the rulemaking. So it's tricky.
Yeah, I would also say too, I think the 2019 guidance, some of the language was a little bit more permissive. You know, it had language like advisors could consider, whereas I feel like the 2020 guidance in places was a little bit more forceful. And again, it's guidance, but I think as Commissioner Lee said in 2019 in her dissent, you know, you ignore it at your peril. So it's not something that should be ignored, but definitely some, you know, a little bit of a different tone, I would say. All right, Steve, let's talk about some of what was covered in the 2019 guidance and some observations there. Or actually, I'm sorry, I'm going to do this one first. The biggest issue that I saw when looking at the was around the advisor's authority to vote proxies. This is where we at the IAA, I would say, got the most feedback. And looking at, do all those things on the slide agree? Some examples here that I heard from members were situations after they reviewed the 2019 guidance, they looked at their disclosures and they found, for example, that that their Form ADV said that they do not vote proxies, but they had some legacy clients where in fact they were still doing some proxy voting. So they went back and made some updates to disclosures. Another example that came up was a firm that said that in its ADV that it did not vote proxies, but it would provide guidance to advisors on voting proxies. And it had no policies and procedures around what that proxy voting guidance or advice looked like. So I think these are some areas that we heard about the most. It's looking at all of those things and do they agree? I think I said last year, do what you say and say what you do. Because this is the area as far as people ask, well, what is the SEC going to look at? This is the low-hanging fruit right here, making sure that all of these things are in alignment. That's what the SEC is going to look at. The most recent enforcement action involving proxy voting involved a situation where an advisor said it did not vote when in fact it did. So Steve, now I'm going to turn to you to talk about some other points that came up in that guidance.
Yeah, and these were some of the more interesting aspects I thought of the guidance. And you know, the SEC is really, for the most part, questioning whether a one-size-fits-all approach is right for proxy voting. And so they laid out whether you can justify, whether an advisor can justify having a single uniform policy. And what they said is an advisor should consider whether voting all of its clients' shares in accordance with a uniform policy would be in the best interest of each of its clients. And so literally, does that mean that you have to go client by client or this bucket of clients to see whether a uniform policy is required? Maybe. By the same token, they say that an advisor should consider whether they should have different policies, voting policies, for different types of clients, including funds or other vehicles. They also articulated the framework that a firm should consider whether for certain types of matters or matters involving certain types of issuers, they should conduct a more detailed analysis. That makes sense. And it's certainly from a high level and the deliberative process that makes sense. It's just curious that the SEC has kind of gotten into this level of detail on something that really amounts to a duty of care issue. Same thing in terms of proxy, sampling of proxy votes and doing an annual review. If an investment advisor makes a decision, proxy voting or otherwise, based upon certain criteria, then they should follow through and make sure that they're actually making that or executing the decision in accordance with their intention. Why it's necessary to call out proxy voting, I don't know, but obviously the SEC has made it clear that they expect that there be some sort of reconciliation. Part of the overlay there is the fact that a lot of firms use proxy voting advisors, and that's an area where historically proxy voting advisors haven't always been able to prove that they voted shares in line with the instructions of an advisor, both because of problems in terms of the direction, or they're not getting votes cast in on time. Anyway, that's what they were focusing on. But I think the first two are important and interesting aspects of the 19 guidance.
Yeah, what are your observations, Steve, now that the guidance has been out for about, what are your observations on this in terms of, are you seeing any changes, or are you seeing areas where maybe people need to go back and take a look at some things? Or
I think it's, Lisa, I think it's too early to tell.
Yeah.
I think firms have gotten into a pattern. I'd be curious Sarah C's perspective, but I think firms have gotten into a set of processes that worked with proxy voting firms or advisory firms, and I think that they'll have to tweak those, but they're going to need to do this in a way that makes sense, given the businesses.
Yeah, so I mean, I did have a few clients after the 2019 guidance who made some tweaks to their policies and procedures. I mean, I think some of the things, Steve, that you absolutely correctly raised here in the 2019 guidance. So say you're an asset manager and you have some, while the wording of the guidance doesn't exactly say this, to me, this is really where the SEC was going. Say you have some ESG focused strategies and some non. It may be, you could think of instances in which the voting actually might be different based on those two strategies. I think where the SEC was a little confused is that's not going to really be in the policy and procedure. That's going to really be in how you think about how you vote. But that is the kind of thing where I think you might have some, there might actually be something to what the SEC was saying about different policies for different kinds of clients. And so, if your policies and procedures need to reflect that you might have different policies or different thoughts around how you're going to vote based on different strategies, right? There's a high level way of saying that. I think another thing that, you could consider again is sort of the sampling. Do you have, if not necessarily in your policy procedure, do you have some kind of desktop procedure just to make sure that the votes were getting cast the way that you intended them to, and if that they weren't, you have some kind of follow-up to make sure that whatever glitches happened in the process get addressed.
There's one note on if you do have separate policies, so you're voting in two different directions, that can happen. I guess one question that firms might want to consider is whether they need to have disclosure about that fact. And the fact that there's a conflict. So if you have proxy matters that you determine are important to two subset of clients, but you're trading on opposite sides, are you getting into a situation that's like you're shorting a stock for one account that you're long for another account, which is something that if you do, people typically will have disclosure about that conflict.
Yeah, interesting point. And Sarah, you mentioned ESG, and we actually got a question: if a proxy voting policy does not consider ESG, but a subset of clients have instructed us to invest in ESG-friendly issuers, should those client proxies be voted with a greater ESG consideration? And I think that's going to go back to what's your understanding with the client on this point, right?
What have you agreed with the client? How are you using ESG and strategy in those client accounts? What kind of ESG, right? There's a lot of different flavors of it. How much is that going to impact the proxy vote? And what have you said you're going to do with regard to engagement? All of that is going to play into into that disclosure and into those policies and procedures.
Yeah. Another thing to toss out just in the way of context, while it's not clear that the SEC is actively examining on the proxy side, that at least on a dedicated basis, it does come up in the context of typical exams. But the Department of Labor is out there examining both pension plan sponsors and fiduciaries right now on issues relating to this, mostly focused on ESG, but it is also picking up proxy voting. And so it is an area that is under very much scrutiny at this point, particularly by the Department of Labor with the pending rulemaking. Well,
and this is probably a good point to mention. ESG and proxy voting are both, they're very political issues. And so it's just, unfortunately, they both kind of become the political football back and forth in different administrations. So something to keep in mind.
Right, and I think the impact on all of that rulemaking, proposed rulemaking that's out there, and even this rulemaking that has gone through, right, what happens in November is a huge determinant of where that all goes, obviously, right? I mean, this could all get rolled back in a way. Although I think it's a little harder to roll back kind of the concepts behind the 2019 guidance, where it had the feel of, geez, if you're using a service provider, make sure they're doing a good job, right? And if there are conflicts, make sure they're disclosed. So that may be a little harder to roll back, but I think some of the other rulemaking may change if the administration changes.
Yeah. Well, what is the SEC's motivation in pursuing this topic out of all the potential areas of regulatory risks that are out there? Is there a history of misconduct in this area? And I would say no, it's more, I think there's some politics that comes into play here. So Sarah, why don't you tell us about, in the 2019 guidance, there was a lot of discussion about proxy advisory firms.
Sure. I mean, I think that there's a lot of concern around the use of proxy advisory firms. As I said before, I think the issuers felt that there were definitely, times where the reports, maybe from the issuer perspective, weren't necessarily accurate, or the recommendation came out in a way that wasn't, exactly how they thought it should have. And so I think the whole focus now is to give the issuer more influence and more ability to say that. And, that has the knock-on effect of pushing onto the advisor, considering whether the issuer is in fact making a valid point, or just, not liking the way that the proxy advisory firm came out on the vote. And it's a tough position, I think, for the advisors to be in, to kind of have to police that, when the SEC could have, in its own rulemaking, done more to the proxy advisory firms, right?
Yep.
But in a sense, they have, through guidance, put that onus on the investment advisory community.
Right. All right, so we're coming close to the end here. We want to move to some key takeaways. Steve, I'm going to turn to you to get us started on that.
Well, I guess I would start from the standpoint of, let's say you're going to have the SEC come in the next year or two, while all of this is in flux. Think about what you're going to want to address or say to them in terms of where you are in proxy voting and all these changes, and the steps that you have taken after the 19 guidance, after the 20 guidance, and in light of all that's still up in the air, about your role as a fiduciary, both your fiduciary obligations under the duty of care and duty of loyalty, but how you view that as translating into proxy voting, and any tweaks that you've made to the criteria that inform your judgments on voting proxies, your arrangements with proxy voting advisors, and of course your policies and procedures and related processes. This is an area in flux, and so it's not possible perhaps to nail things down with concrete, comprehensive changes because of the changes, but a deliberation on your part at this point is sensible as a fiduciary, and is something that should be acceptable to the staff, even though they may think that you could have gone further in one way or another. There is a lot of static here. with things in flux.
Yep. And I would also come back to do what you say and say what you do. It's also a good thing to
Right.
keep in mind in this area. Unfortunately, our time is up because we're at 1 o'clock, but I did want to thank Steve and Sarah both for your participation in the webinar today. We really appreciate it. I also wanted to mention that registration for our briefing webinar next Wednesday, September 16th, and our Leadership Week on October 5th through 8th are available on our website. So we encourage you to register for those. And thank you everyone for attending.